Il y a un petit changement dans le programme, puisque notre collègue Julia Iliopoulos-Stangas n'a pas pu venir. Rien de grave, mais elle a eu un empêchement un peu de dernière minute. Et donc, mes collègues m'ont demandé de la remplacer au pied levé pour présider cette session. C'est un deuxième sujet dont on parle peut-être un peu plus quand même entre juristes que du premier, mais qui est assez nouveau dans la manière dont il est formulé, c'est-à-dire dans le titre allemand, qui est celui qui est le plus précis, je crois, Gesundheitsvorsorge als eine neue öffentliche Aufgabe. Dans ce sens-là, il y a sans doute quelque chose de nouveau, parce qu'en réalité, sur la santé, déjà, depuis la mise en place du système bismarckien, il y a à peu près 130 ans, c'est une tâche publique que d'avoir des systèmes de protection financière de la santé. Et puis, bien entendu, on a eu toute une série de systèmes et nous savons bien que l'Europe a cette originalité d'avoir soit avec des systèmes de type bismarckien, soit avec des systèmes de type Beveridge, des systèmes de santé qui font partie et qui sont des thèmes de droit public. Il m'est arrivé moi-même, il y a très longtemps, d'enseigner le droit à la santé en France. Et c'était un thème très intéressant parce qu'on faisait à la fois du droit administratif et du droit privé, étant donné qu'il y avait également les hôpitaux privés. Mais là, on va dans une autre direction qui est évidemment appelée en premier lieu par la pandémie. Et surtout, il s'agit de voir la question à différents niveaux, à voir évidemment, comme d'habitude à la SIPE, en droit public comparé d'État européen, évidemment, comme d'habitude à la SIPE, en droit européen, évidemment, comme souvent, il faudrait dire toujours à la SIPE, en droit du Conseil de l'Europe. Et ça, c'est un thème sur lequel moi-même j'ai travaillé beaucoup. Et ce qui est intéressant dans le Conseil de l'Europe, c'est que la Convention européenne des droits de l'homme ne contient pas de droit à la santé, ce qui est logique d'ailleurs. C'est dans la Charte sociale européenne qu'on trouve cela. N'empêche que la jurisprudence de la Cour de Strasbourg est extrêmement intéressante parce qu'elle a tiré du droit à la vie, un droit à la santé, avec des obligations positives pour les États membres. Et puis, il y a le niveau international avec, évidemment, l'Organisation internationale de la santé. Et donc, nous avons deux experts et je donne tout de suite la parole à mon collègue, le professeur Luca Mezzetti, de l'Université de Bologne, qui va nous parler de Globalization of Healthcare Policies. Is healthcare in its multi-level dimension, global, European and national, a new constitutional problem? 30 minuti.
Thank you, Mr. President. Thank you for the invitation to my dear friend and colleague Vasco Pereira da Silva and the University of Lisbon and the Società Juris Publici Europei. Okay. As the President has announced, my topic will deal with the multi-level dimension of healthcare policies and the connection with the constitutional law. I want to say if it is a new constitutional problem, or maybe if there are many constitutional problems in this field. The rate of transmission of the disease has been, as you know, high. The containment strategies ineffective or partially ineffective. The responses offered by the various actors, so the international, supranational, national level, partially inadequate. In view of the global circulation of people and goods, only a globally coordinated action could have lead to results, to satisfactory results in containing the spread. According to the critical voices that have invested the WHO, the World Health Organization, a more decisive and immediate reaction to the pandemic would have allowed a confinement of the infection and the more limited spread of the virus. The action of the states was subsequently characterized by unilateral measures and the absence of common strategies, both with regard to the times and to the methods and intensity of the interventions. The inadequacy of the response to health emergencies was determined not only by the intrinsic weakness of many national health services, but also by the incapacity of the organization, of the World Health Organization itself, to intervene effectively, both for financial reasons and for the limited powers granted to it. Also, the set of changes made to the international health regulations of 2005 have increased the powers of the WHO. Some basic problems remain that prevent the action of the global regulator from having sufficient effectiveness. The most important of these concerns compliance. The obligations of states exist and have been strengthened, but there are no mechanisms capable of countering any inaction or violation of obligation by states. Starting from the information duties, to the offer of collaboration, to the possibility that the WHO acquires information from non-governmental actors. Everything requires that states are willing to accept international interference, that they are willing to open their system to the intervention of an international player, and to decide to entrust the management of the health crisis to the WHO. There are no sanctions in the case of non-compliance, nor there are courts or tribunals to which the organization or other states can denounce or claim the violation of the obligations contemplated in the international health regulations. If the powers of the WHO to manage international health crises encounter limits and resistances in the sovereignty of states, it could be assumed that in the European area, and in particular in the integrated legal space of the European Union, the power to coordinate the action of the member states by the institutions of the Union can find a firmer and more secure anchorage. Yet the COVID-19 pandemic has highlighted the Union's difficulty to manage the health crisis produced by the spread of the virus and to prepare a response plan which has seen the member states to find national solutions to a problem which, given the obvious impact on the main economic freedoms provided by the treaties, was evidently also European, not only, but also European. One of the key tools that was supposed to ensure European coordination of the pandemic response, the European Center for Disease Prevention and Control, ECDC, has remained completely or largely marginal in the crisis. There are many reasons for this marginality. I will concentrate my attention on the legal one. There are political and legal reasons, but I would concentrate my attention on the legal one. This reason is linked to the competencies of the Union. With regard to the protection and improvement on health in particular, Articles 4, paragraph 2, litera K, and Article 6 of the Treaty on the Functioning of the European Union. The treaty provides that the Union has concurrent competence with the member states with regard to common problems of safety in the field of public health as regards the aspects defined in this treaty, and also as a complementary competence aimed at supporting, coordinating, or completing the action of the member states. This last competence is then declared in Article 168 of the Treaty of the Function of the European Union. In particular, it is established that the support and complementary action of the Union includes the fight against the great scourge, promoting research on their causes, their spread and their prevention, as well as health information and education, as well as surveillance, warning, and the fight against serious cross-border threats to health. The set of instruments prepared by the European Union did not allow for a unified or at least coordinated response to the pandemic. The Health Security Committee did not meet to identify a possible coordinated response to the health emergency caused by the COVID-19 until March 25 or 25th, 2020, while the states had already identified their strategies. And the Center for Disease Prevention and Control has struggled to act as a link between the apparatus of the member states, the center itself, and the Commission. The events related to the spread of the COVID-19 pandemic have highlighted the impotence or the difficulty of the health crisis regulation system headed by the WHO and the international health regulation towards states that do not comply with global rules. Already in the past, the limits of intervention by the WHO had led to reflect on the opportunity of strengthening the system of enforcement of international rules. It is therefore not surprising that the enormous economic, social, and political implications produced by the current pandemic and by the conduct of some states, in particularly China, in the first period of the contagion, push in the direction of a strengthening of the powers of international regulators. Obviously, the transfer of greater competencies and powers to the WHO, if it can solve some compliance problems, first of all, raises delicate problems of accountability. Therefore, if on the one hand, it is clear that the compliance of states with international regulations could be guaranteed with the attribution of more incisive powers, it is also necessary to ensure that the mechanisms that are built beyond the state correspond to the minimum guarantees of the rule of law, can count on bodies endowed with accountability and capable of ensuring the transparency and reasonableness of their decisions, particularly as privacy, health data are concerned. But it is also a problem of coordination with the policies to support the economic crisis that the restrictive measures can provoke, which go beyond the scope of a global sectoral organization, such as the WHO. It is difficult, it is problematic to attribute the whole responsibility to the World Health Organization for the consequences produced by the spread of the COVID-19 pandemic, as it seems improper to reproach the European Union for its inability to offer a coordinated and unitary response at the European level. In both cases, the attribution of competencies beyond the state is incomplete. In the case of WHO, despite the considerable progress made with the international health regulations and the recognition of the significant autonomy to the Secretariat of the organization, the loop of compliance remains, for which there are still no mechanism and guarantees capable of affecting the sovereignty of the states. In the case of the European Union, both the set of competencies and the pure information mission of the center keep the strategic decision of response to the pandemic in the hands of the states, unless the states themselves, making a political choice, decide to build, together with other states, a coordinated response. In this scenario, corrective and desirable interventions would be possible in both dimensions. On a global level, it would mean reinforcing the existing mechanism, preparing a system of enforcement of the rules contained in the international health regulations through the establishment of arbitral tribunals or a court appointed to decide disputes between states arising from the violation of the international obligations. In the context of the European Union, it would be a question of strengthening the common management capabilities of the health emergency, strengthening the already existing coordination tools or identifying new ones, and thus matching the economic measure now put in place for reconstruction with adequate powers in the pandemic response and management phase. Both of these corrective, however, are not easy to make in an historical moment in which worrying signs of closure of states to the international dimension can be glimpsed, in which the dialogue between national court and international and supranational courts is sometimes abruptly interrupted, and in which international law itself seems to be placed in crisis by the issue of compliance. Considering these problems of enforcing international measures, of accountability, of compliance, we can say that there is still a strong struggle between the international level and the national level for managing health crisis. In front of the adoption by each state of restrictive measures imposed by the pandemic, the Union law, the European Union law, or the supranational law also acts as a parameter of legitimacy of the limitations, which must be consistent with the principles of necessity and proportionality proper of the European Union law. On the other hand, this does not only concern the profile of the compatibility of national measures with respect or with regard to the principle of European Union law, but also the possible impact on rights and freedoms guaranteed by the supranational charters. Above all, the European Charter for Fundamental Rights and the European Convention for Human Rights. In fact, the Charters of Rights themselves establish that the measures take into account an adequate balance between the needs of freedom and the needs of security. For this reason, the possibility of access to the European courts when national measures conflict with the supranational charters did not seem so remote, and in fact, cases of censors have been recorded with respect to measures considered disproportionate to the purpose. Always bearing in mind that the emergency aspect is not ignored by the Charters of Rights themselves, which provide for adequate derogation mechanism, such Article 15 of the European Convention, Article 52 of the European Charter for Human Rights, which aim to reconcile the transitory criticality with the preservation of an indispensable minimum guarantee of rights, both from a substantive point of view, fixing the rights that in no case can be subjected to limitations, and from a procedural point of view, with transparent communication duties on the states. Despite the attempt made at the European level to ensure a certain coordination of responses, and therefore a substantial homogeneity in the management of the pandemic, we have the impression that the competence limits of the Union in matters of health and have allowed the states to carve out a wide margin of maneuver in the adoption of emergency measures. In fact, the burden of the most controversial decisions has fallen on the national authorities because they affect fundamental rights and freedoms, often without solid basis both on a scientific and on a legal level, which have highlighted the loneliness of the state in the face in front of pandemic, marking an evident short circuit between reality and needs. On one hand, the lack of supranational coordination tools in a matter such as that of constitutional freedoms, still jealously enclosed in national legal system. On the other, the awareness that these events, due to their global nature, escape the full domination of states. In synthesis, the state is still the dominus of the emergencies, but the pandemic emergency, for several reasons and features, escapes the dominion of the state. Also, the pandemic has, in a certain sense, eroded the sovereignty of states, understood as the freedom and discretion of political ends that materialize in legal production, and therefore in the legal sources. The role that nation states have had in emergency management seems to testify, on the contrary, a full vitality of the concept of sovereign state. Therefore, probably the pandemic has not led to any decline of sovereignty in a subjective sense, but mostly an erosion of it in terms of action. A sovereignty which, however, returns, in spite of itself, more for a gap than for a conscious option. Therefore, we need to verify if sovereignty on a national basis is still adequate for a global context and for a supranational character that characterizes the crisis of the last century. The lack of effective coordination on every aspect of the limitations and the specific needs of each state have led to a wide diversification of the measures, or to using the same tools but in a different way. For instance, in the case of the Green Pass tool. On a general level, the legal sources of the emergency always have a close connection with the action of the executives. Just as the parliament leaves the government wider margins of action, so the typical sources of the latter, both primary and secondary, temporarily erode the space that are normally reserved for statutes. And like any emergency deserving of the name, even the one caused by the pandemic has seen a particularly active executive in terms of regulatory production, a pinning up of executive action. Indeed, it almost seems possible to state that the intensity of the legislative action of the executives, also in terms of the originality of the solutions, is directly proportional to the vastness of the emergency. The impact of the pandemic on the legal sources system as an emergency in the pure sense of the term has led to the proliferation of provisional measures of immediate application and destined to remain in force for the permanence of the circumstances that determine them. The need to adapt regulatory responses to the concrete needs of the emergency has sometimes led to doubts about their compliance with the constitutional model of regulatory production. Also thinking to the relationship between the state level and the local autonomies level. A recurring question in doctrine, in fact, concerns precisely the fact that the pandemic law has given rise to an innovative and atypical model in legal production, even if the positions, albeit with not negligible critical voices, mainly settled in the opposite sense. So I think, concluding that the tasks for constitutional lawyers that the pandemic left us are many and very difficult. To study a typology, a new typology of emergencies that are today no more only war emergencies, but also climate, energy, health emergencies, first of all. Second, the relationships among legal sources at the constitutional level, national or domestic level, but also thinking to the relationship with supranational levels, and the management of the new emergencies in the relationships or in the context on the framework or relationship between the state level and the local entities, regional, federal states are concerned. Thank you very much for your attention.
Merci. En vous écoutant, je me suis souvenu, il y a un peu plus de 20 ans, j'avais assisté à une réunion de la Convention européenne, celle qui a élaboré le projet de traité constitutionnel. Et pendant cette réunion, il y avait une intervention de John Bruton, ancien Premier ministre irlandais et membre de la Convention, représentant du gouvernement irlandais. Et John Bruton avait fait un plaidoyer extrêmement passionné, ce qui est inhabituel pour un Irlandais, pour dire qu'il faut absolument que l'Europe s'occupe des épidémies. Il avait rappelé la grippe espagnole. Rien ne s'est passé. Pourquoi? C'est pas que les États ne voulaient pas plus de compétences en matière de santé, mais c'est qu'à partir du moment où on ouvrait la question de modifier des articles de ce qui est ce qu'appelle maintenant le TFUE, chacun venait avec ses oui et ses non. Et le plaidoyer de John Bruton est totalement tombé dans l'oubli. Souvenez-vous aussi qu'il y a maintenant 3 ans, on a tout à coup redécouvert que la grippe espagnole avait fait 80 millions de morts. Hein. On avait l'impression que c'était 2 ou 3, 80 millions de morts. Il y a même des historiens qui disent que la grippe espagnole est sans doute une des causes les plus importantes pour lesquelles l'Allemagne a perdu la Première Guerre mondiale, parce que les soldats allemands étaient plus affectés que d'autres de la grippe espagnole. Donc, c'est pour dire que le problème n'est pas nouveau. Est-ce que nous allons réussir à trouver des solutions nouvelles? C'est une autre question. L'une des pistes, c'est évidemment les obligations positives pour les États, mais je m'arrête là et je donne la parole à Maria João Estorninho, qui est professeure de droit administratif à la Faculté de droit de Lisbonne et spécialiste du droit de la santé.
Merci. Merci, Monsieur le Président. Je voudrais dire, professeur Jacques Siller, c'est pour moi un vrai plaisir, un honneur d'être ici sous votre direction. Et je salue aussi professeur Luca Mesetti et tous nos collègues. I brought some slides. I'm going to speak in English. I brought some slides to try to discipline myself because we have lunch afterwards. And so let's see. The COVID-19 pandemic has led to an emergency administrative law with an ephemeral vocation, born in times of horror and uncertainty under the banner of urgency. Like a tsunami, the fight against the pandemic, under the guidance of WHO, caused successive waves of legislative packages that swept through different sectors of the legal systems. In administrative law, the effects were visible in both administrative organization and administrative activity, as well as in what regards the control mechanisms of the public administrations. And of course, from the starting point, the definition of public interest, public good, collective needs, whose satisfaction is the responsibility of the public administrations. Hearing Professor Luca Mezzetti speaking of the difficulties in the constitutional level, I leave a provocation in this starting point, whether harmonization and globalization are achieved by or through administrative law. Let's think a little bit about this. In administrative law nowadays, new answers are needed for classical questions. From a teleological point of view, what is considered nowadays to be public good? From an organic point of view, who is in charge of public administrative tasks? And what is the meaning and the implications of our classical legality principle and other administrative principles? And finally, who controls public administration? The increased interdependence among individuals and countries in a globalized world has facilitated, as we unfortunately witnessed, the rapid spread of COVID-19. The pandemic phenomena is not new, of course. Professor Ziller just mentioned the Spanish flu, 1918, 1919, spread mainly by the military and causing millions of deaths. Or let's remember, just to mention the 20th century also, 1957, 58, the Asian flu, 2002 for SARS epidemic, 2009, the swine flu. But the dimension of the phenomenon is totally different this time, on an unprecedented global scale. With the globalization of tourism, traveling, trade, viruses, namely SARS-CoV-2, became global menaces, demanding global responses. While globalization has played a role in the rapid spread of COVID-19, it also offered opportunities, it also demanded for international cooperation, scientific advancements, and collective efforts to combat the pandemic. And from 2019 on, the global response to COVID-19 highlighted the interconnectedness of public health and the need for international collaboration. WHO has played an important role in addressing this global impact of the virus and working towards its containment. Recognizing health as a global public good has led to development of international frameworks and initiatives aimed at addressing global health challenges collectively. After COVID-19, I think that nobody doubts of the importance of preparedness, of effective, more resilient and inclusive public health systems, and of course, of global cooperation in mitigating the impact of future, unfortunately, more than certain pandemics. Here is a list of some of the roles, the tasks of WHO during COVID-19 pandemic, taking, of course, a myriad of responsibilities. We will have the opportunity to come back to some of them in a while. But let's start from the beginning. Who can forget the terrific image of Director General of WHO on 11 March 2020, declaring COVID-19 as a pandemic? Such declaration worked as a trigger all over the world. In Portugal, for instance, even yesterday, our president talked about his declaration of the first emergency state on 18th of March in the same week. From a legal point of view, however, of the utmost relevance is what happens on the 30th or had happened on the 30th January 2020, based on Article 12 of the International Health Regulations, following the recommendations of the Emergency Committee, when the Director General declared the outbreak of a PHEIC, which means a public health emergency of international concern, which is a formal declaration by the WHO of, and I quote, an extraordinary event which is determined to constitute a public health risk to other states through the international spread. One of the issues that we can debate and should debate and is in discussion nowadays is whether a pandemic declaration should be introduced as an official legal concept in the international health regulations as a step up of in comparison to the other declaration, with all the consequences in terms of powers to combat, to fight such a situation. WHO's role during the pandemic has implications both at national, regional and global level, and has contributed to the harmonization of administrative law. Here are some examples of topics that we could, but have no time to develop regarding this influence. Just to mention some aspects, national administrative bodies all over relied on the information facilitated by WHO on the pandemic spread, impact, best practices, and had to adjust their administrative measures accordingly. Countries learned from each other's experience and aligned their administrative approaches, which helped, this collaboration helped to establish common administrative standards and practices. The technical assistance and the capacity building support to member states led by WHO was also important from this point of view. Of course, standardization of guidelines, very important, influencing national administrative laws and policies, as countries all over the world align their domestic legal frameworks and regulations to those international standards. Especially in areas that we remember, like testing, contact tracing, quarantine measures, travel restrictions, vaccine distribution, and so on. And member states were really required to develop administrative systems and procedures to comply with these regulations, reporting outbreaks, implementing surveillance measures, collaborating with and other nations. International health regulations revised in 2005 following the SARS epidemic of 2002 and 2004, of course, have established, and it was a step very important at the moment, have established a global surveillance and reporting system and set national minimum mandatory controls to prevent disease. The question arises nowadays after COVID pandemic to know if, to wonder whether this is enough. Of course, we all, and here nobody has doubts about it, the degree of harmonization varies depending on the national legal systems, as well as cultural contexts, policies, and political priorities. WHO's guidance and recommendations during the pandemic have encouraged flexibility and adaptability within administrative law frameworks, allowing governments or stimulating governments to respond swiftly and effectively to public health emergency. Here are some examples of ways, of tools that WHO used to promote this flexibilization of administrative law. I am going to point out some of the risks. As Professor Ziller said, I'm an administrative professor, so it is natural that my concerns are connected with this point of view. I think it's very important to note that while flexibilization of administrative law can enhance the response to crisis, it must be balanced with accountability and transparency. The temporary flexibilization of administrative procedures should be clearly defined, time-limited, and subject to appropriate oversight mechanisms to prevent abuse and to ensure the protection of individual rights and public interests. I'm convinced that with regard of administrative procedure law, it is possible to identify lines of continuity and lines of disruption during the pandemic phase. In terms of balance, I think that in this matter, the emergency law resulted in what I have already said, a disruptive continuity. In fact, emergency law deepened trends that for years had underpinned successive reforms of the law applicable to decision-making procedures. From night to day, administrative dematerialization effectively became a reality. In the name of urgency, in fighting the pandemic, the most different measures of debureaucratization and procedural simplification were adopted: shortening of deadlines, waiver of formalities, notifications, and others. I think that the procedural simplification measures go so far that although in a line of continuity in relation to the trends already affirmed in the last years, the final results close to non-proceduralization or deproceduralization of the administrative activity, for instance, in the case of public procurements all over our legal systems, ends up being deeply disruptive in relation to the model of administrative law that we had from the mid-20th century. It is very dangerous, I think, to just abandon one of the characteristic features of administrative law of the second half of the 20th century, the fact that the administrative procedure in itself is a guarantee, a safeguard for the individuals in their relations with administrative powers. So if in pre-pandemic administrative law, there were, for instance, growing logics of privatization, of contractualization, of participative and concerted procedures, even in the case of the practice of administrative acts, unilateral decisions, one of the most striking aspects of emergency administrative law was undoubtedly the re-emergence of public authority powers, impositions, prohibitions, sanctioning powers, the replacement of agreements by civil requisitions, and so on. Emergency administrative law supports a public administration that protects and provides goods and services, public health services, for instance, as never before in recent years. But above all, it supports a public administration that also, as never before in recent years, prohibits, imposes sanctions, quarantines, confinements, wearing of masks, curfews, bans on visiting homes or hospitals, inmates, bans on meetings, religious ceremonies, travel restrictions, among so many other measures that we know. They have meant restrictions on fundamental rights that had not been imagined for a long time in our countries. Many are the issues that must be revisited regarding the legal block that binds the public administration and whose porosity has reached worrying levels in emergency legislation. It is enough to bear in mind the real risk of erosion of the constitutional foundations of administrative law and the variable geometry contours that the administrative legality assumed in the pandemic and that in fact persist in this return to our new normality. Force us to reflect on the risks and consequences for our traditional understanding of the democratic rule of law. I'm not going to deepen this topic, just of course to remember that Europe, in Europe, the states, the countries hold primary responsibility for organizing and delivering health services, but of course, I couldn't leave these two topics out of these words. Two examples of recent developments in what concerns healthcare in this multi-level dimension, global, European and national, and in this case, European and global. The initiative of digital health just this month, June 2023, a partnership between the EU and WHO has taken place some days ago because WHO decided to take up the European Union system of digital COVID-19 certification to establish a global system for future health threats. And also the European Health Emergency Preparedness and Response Authority that was formalized in December 2022. Just to remember in terms of Europe that we know that from late 20th century, in the framework of global knowledge and risk society, we have already witnessed the integration of public administrations in network administrative systems, namely in Europe. And I think that nobody doubts that the pandemic deepened this tendency. In the era of the return to physical borders and confinements, administrative bodies have opened up to multi-level cooperation networks at a supra-state level. So finally, I'm skipping COVAX. It would be an interesting case study for these and for the difficulties and fragilities of everything we are talking about nowadays. But just to conclude the last slide, I would just in my some minutes that I have point out some two fragilities and two topics for discussion in terms of reforms of WHO. Doubts have arisen about the role of WHO during the pandemic, particularly in relation to the authority, the accountability, the decision-making processes. I think that it is very interesting and very, very important to analyze WHO actions in light of our traditional administrative principles. The question of authority to issue guidelines and recommendations, to enforce compliance, the the importance of those principles when assessing the lawfulness, the proportionality, the duration of emergency measures suggested or recommended by WHO. Of course, the concerns about transparency of decision-making process within WHO, including the handling of information, the scientific advice, which is already a classical problem, but of course it gained new dimensions, the relation between administrative decisions and scientific advice, and of course the influence of political considerations. A second topic, of course, is connected to the fact that the architecture of WHO and the international health regulations is built upon the premise that states will cooperate in case of a public health emergency. So if a country refuses to cooperate and take appropriate precautions to control outbreaks, it becomes obviously difficult to contain the spread of disease. And we know that WHO works in collaboration with the member states, has little autonomous authority of its own, relying upon the national governments for funding, for access and implementation. National governments and that would be another topic, private entities, and in what regards the organic evolution in terms of administrative law, obviously the coexistence of traditional public entities and private entities in this global new reality. WHO has faced increasing international health regulation violations from states and had limited influence in the COVID-19 response. And of course, let's bear in mind the limited effectiveness of the ACT accelerator or the COVAX initiative in particular. So nowadays, a choir of voices are in favor of WHO reform. And what is being discussed in order to try to strengthen and fortify its current architecture are several proposals. I would try to bring to the debate some topics that I find important. For instance, reinterpreting or a new interpretation of some of the articles, for instance, Article 12 of the International Health Regulations on determination of the declaration of a public health threat in light of a precautionary principle. Does it make sense? For instance, overcoming the minimalistic interpretation of Article 2 of the International Health Regulation that defines the scope of these regulations and have been interpreted in a minimalistic way. And also revisions to provide authority for enhanced surveillance and mandatory reporting, including not only public authorities, but civil, academic experts, scientific institutions, increasing transparency, the global funding, of course, mechanisms, and the question of eventually maybe imposing sanctions of the members for non-compliance. Really, to finish, just the last topic, a pandemic treaty. Negotiations are underway in Geneva these days to amend the International Health Regulations of 2005 and to create a new WHO Convention on Pandemic Prevention, Response and Recovery, a pandemic treaty. One should bear in mind to debate that topic the difference in the WHO constitution between mechanisms of Article 21, the adoption of regulations by the World Health Assembly, which are legally binding unless the states expressly opt out, reject, and it would be the case of a pandemic treaty. Article 19, the negotiation and approval of a convention, a treaty, which requires 2/3 majority and needs a national ratification in light of the constitutional regime in every country. And so the question is whether it is possible, it is feasible, is there political will, are the states represented in the World Health Assembly really willing to, and they say it will be to 2024, next year, is there really a political will to approve such a pandemic treaty? And my provocation, going back to the initial provocation, is it desirable? I would like to hear your opinion, but from my point of view, I'm not sure if this conviction that a rules-based international order, I'm not a special in public international law, I must confess, I'm just an administrative professor, but I'm not convinced that such a conviction offers really, and the idea that it's needed a more robust rules-based international alternative to the ad hoc diplomacy that has prevailed to date is the path that we should go on. And in going back to the first provocation, we have an enormous degree of harmonization, and so globalization, or at least Europeanization, when we compare our legal systems in health regimes, in public procurement, very important in what concerns health and the fight against the pandemic, through administrative, or what we traditionally consider administrative law. But I give you the floor. Are you optimistic? Which is the best way? Thank you very much for your patience.
Merci beaucoup pour ce tableau extrêmement large, et je crois que vous avez vous-même déjà lancé quelques questions qui peuvent apporter des réactions, et donc c'est à la salle maintenant de réagir, de poser des questions, de faire des propositions. Nous avons un bon quart d'heure pour ce faire. Dans le fond, in the back. You know, tu es le second. Il y a une personne avant toi derrière. In the back.
Thank you, Luís Pereira Coutinho from Lisbon. Thank you very much for both presentations. They were very interesting. First, I have a question for Professor Luca Mesetti. I very much agree with your point about constitutional clauses not being prepared to address circumstances such as pandemics and financial crisis and climate change. They are designed for crises such as war, civil unrest, etc. But the problem is what to do while constitutions are not reformed, while this paradigm of exception is still the classic paradigm. For instance, when competence norms are violated, as they were in many states, with the government issuing norms about fundamental rights, for instance. The problem is, how should a constitutional jurisdiction react before such a circumstance, if the measures really are needed, if they are really necessary from a material point of view, but they still violate organic norms of the Constitution. It's a difficult question because we cannot accept perhaps balancing between organic norms and material norms, but could one hypothetically accept something like a political question doctrine while these constitutionals are not reformed to address these sorts of circumstances? And regarding I have another question which applies to both panelists and answering the challenge made by Professor Maria João Storninho about whether this is a good idea to go forward. Well, I'm skeptical. I fear an epistemic government, so to speak, against democratic accountability, which only takes place at a national level. I know this is a very difficult subject again, but should one go down that road of epistemic government when addressing even circumstances as hard as this? This is a doubt. This is not really a position. Thank you so much.
Thank you. The floor is to, Chuchai.
Thank you very much. Sorry to take the floor again, but this topic is one of the most interesting concerning the whole issue of this Congress. And I have one question to Professor Mesetti and one question to Professor, sorry, pronunciation of your name, the Professor Estegnino. Scusi. And I think that from a constitutional point of view, the state of emergency, which was declared at the national level in almost all member states, has raised a lot of questions. I don't want to mention some member states, but concerning the pandemic, the state of emergency is still in force. And the result of that is that practically the country is governed by government decrees. And the role of national parliaments and their powers are substantially reduced. How do you feel this? Because the pandemic is even declared by the World Health Organization as terminated. So then based on what legal ground, what constitutional legal ground, a state of emergency declared based on the pandemic and following the declaration of the WHO is still in force and giving unlimited power to a government to govern a country? And that's one question. And the second one is about the Conference on the Future of Europe. The AFCO committee of the European Parliament will vote next month on its report, hopefully, concerning the Parliament concrete proposals based on Article 48 of the Treaty on European Union to convene a convention. And the Parliament will make concrete proposals. And one of the areas where they are working very hard to develop concrete proposals is the health sector. how the treaty could be amended in order to overcome all those difficulties which we have experienced in the last 3 years. Because you mentioned the HERA, but it was a very difficult process to adopt it. I think, and we have not yet spoken about, but there is a big issue here, and that's the principle of subsidiarity and the shared competence problem. And what is already national competence, exclusive national competence, because the health area is extremely sensitive for member states. So there is a competence issue here, which I also wanted to learn more from the panelists. Thank you very much.
There is a question by Professor Carullo. Here. And then Professor Sarsi.
Thank you very much for your interventions. I'm Gerardo Carullo from Milan. I have just one question, comment for Professor Estornino. It's a question / comment because one peculiarity of pandemics is that they are unexpected events that nature surprises us with and surprises us with in a way that we are usually not capable of controlling them with the tools we already have from a scientific point of view. If we had like a cure ready for it, probably would not develop into a pandemic. So my dubbed, which is a dubbed common question, isn't it? I don't want to sound rude at all. So if I sound rude, it's just for a language problem. Could it be naive to think that we can establish a legal framework of any kind that can counteract something that we cannot counteract? So whatever framework we set up, it's deemed to fail because we don't have. So this is, yeah.
Paulina Starsky from Freiburg. Thank you so much for 2 excellent presentations. I would have a question or comment to you, Professor Estornino. I found your presentation excellent, and I just recently read an article about COVAX, which is like a public-private partnership that dealt with the distribution of vaccines internationally. Also the WHO participated in that, and the basic contention of the article was the output legitimacy was really bad because the distribution didn't work as it should be. And my question would be, you presented yourself as an administrative lawyer, but in the end, there are basic fundamental constitutional questions behind that. And what else could answer that than a rule-based order? Because you were quite critical about that, an international rule-based order. So I think that's what we actually need. And I think COVAX was one example of that. Would you agree or disagree with that?
D'autres interventions? Oui.
Merci beaucoup pour ces excellentes présentations et aussi les questions. Donc, je vois le temps passe, donc je vais vraiment rester courte. Mais ce qui m'intéresse à cet égard, c'est aussi en fait la situation. Est-ce qu'il existe une recherche par rapport aux solutions des juridictions suprêmes ou constitutionnelles? Quand même, parce que même si on n'a pas de compétences, on voit la jurisprudence en cette matière de la Cour de justice, du tribunal, par rapport à l'accès au bâtiment, par rapport au voyage, par rapport aux obligations ou pas de se faire vacciner. Et par exemple, la Cour constitutionnelle tchèque, comment dirais-je, a évité de donner la réponse en disant que la pandémie est finie et donc on n'a pas de réponse, mais quand même, toujours la jurisprudence, malgré la compétence manquante, est appelée de donner des réponses dans les différentes matières. Donc, je me pose la question sur la recherche ici. Est-ce que ça pourrait nous aider quand même de donner plus de base pour le développement des compétences et aussi des réponses à ces questions qui intéressent tous les citoyens européens? Merci.
D'autres questions? Alors, je vais me permettre répondre à votre, entre guillemets, provocation. Il y a déjà eu des réponses sur un traité sur les pandémies. Ce que je crains beaucoup, c'est un phénomène qu'on voit ces jours-ci formidable. L'Assemblée générale des Nations unies a adopté un traité sur le plastique dans la mer. Bon, le traité est là. On le met et rien ne se passe. Rien ne se passera avant quelques années. Et là, je crains un peu que l'attention sur un nouveau traité, ça permette à beaucoup de se donner bonne conscience facilement en laissant les travaux à des techniciens au lieu de se poser des questions. La seule question qu'on ne peut pas répondre, à laquelle on ne peut pas répondre, c'est ce que Gerardo Carollo a dit, comment prévoir l'imprévisible. Mais enfin, on ne peut pas trop en demander aux juristes. Je propose de donner la parole dans le sens inverse pour répondre. D'abord, professeur Cassouillet.
Thank you very much. Thank you very much. Just 2 words. It was really a provocation, and I was being ironic in what concerns the relation between constitutional administrative law. We could go back to the 19th century and discuss those relations, and I was being ironic, and you of course understand that. There was a question very interesting about we were here thinking mainly of the problems issued by non-compliance by the states to the recommendations, and then suddenly you had the example, or you brought the example, the contrary example. The pandemic formally is over. The WHO declared the end of the pandemic, and still some governments continue. And that happens dramatically on a constitutional level, of course, and we all agree that that is very worrying. From the constitutional point of view and the rights of citizens in those countries, of course, but it happens also from an administrative point of view. The pandemic is over, but our legal regimes about public procurement, resource allocation, which are very, very important in the end, they are still they were not revoked in several of our countries, maybe in some countries in a more worrying way than others, but well, I'm not going now to be much more critic about that. With the extension of those administrative deproceduralization for until 26, 28 already in our legal regimes, which is really amazing. And then I couldn't agree more with the doubts about the effectiveness. My provocation was in that sense. I don't believe that that will be a real solution. Maybe it's a cosmetic solution, but maybe real solutions. For instance, we can use COVAX case study. I skipped the slide. It is really a case study. It could be analyzed in its fragilities, in its good intentions, in the way it was organized, and the fragilities and the results that it didn't, that were not the expected ones, and that involve lots of issues regarding the procedures of vaccine regulation and approval, distribution, financing, of course, the sources of financing, the decisions, the contracts, the agreements, data protection, privacy. Well, it would be an issue for another intervention. And I agree, just to finish, that of course reality will never be the same. So we cannot think of a legal regime that is going to, but the idea of being prepared, having the mechanisms to be prepared whenever anything unusual occurs, being able to find solutions, that makes sense for me. Not the rules in itself, the articles of the regulations, but the more important, the ways of coordination and division of responsibilities and so on.
Obrigado.
Merci beaucoup, Monsieur le Président. I will try to only a few words for answering 4 questions. I will connect the answer to the first with the answer to the 4th question. What to do in case of non-reform of the Constitution? I would distinguish. I want to say our century is the century of the judiciary power, and particularly of the Constitutional Court and the Supreme Court, when the legislator, both on the ordinary level or the constitutional level, do not adequate statutes and the Constitution to the evolution of progress, technical, economical, and so on. This is obviously a particularly strong problem in the case of some emergencies as the climate or health or energy emergencies. I would distinguish between the role of the legislator and the role of or legislator as constitutional reform legislator and as the general competencies framework is concerned, and the human rights sector. In the case of human rights concerning these different frameworks, probably a role that is still in force, already working, sorry. A very important role is played by Constitutional Court and the Supreme Court in order to create or extend already existed fundamental rights. So this extension or details that are given by constitutional courts or Supreme Courts to already existing constitutional rights or creating new ones. This very strong creative role of the judges. And this is a solution that only partially satisfies the needs of our times, because contemporary constitutionalism tries to give a solution to a pathology, that is, the pathology is the absence of the legislator not reforming the constitutions, but at the same time, to this pathology, the answer is another pathology. So the so strong creative role of constitutional courts that are not, they have not a direct legitimations, and that are not supported by a popular vote. Is there any solution? I think it's one of the most difficult tasks of for constitutional lawyers, contemporary constitutional lawyers. I know only a very few solutions in constitutional comparative law to this question. Second, the question of constitutional competencies, and the question of constitutional organization. So which body is doing what? For instance, we have experimented in Italy a very problematic deformation of the constitutional and particularly governmental organization, with a strong polarization of competencies to the president of the government, and the very dangerous, I think, use of decrees, pure decrees of the president of the Council of Ministers to manage the pandemic. This typology of decrees are, I would say, third level, so basic level legal sources. They cannot be submitted to the Constitutional Court for judicial review, and so on. So what I see in this sense is a type of degeneration of constitutional organizing or organization models. What can be done, for instance, against these decrees? A claim to the administrative judge, the only way. And now there is another problem. Is that in the administrative judge really independent from the government, or is the judge offering an endorsement to the government? This is another difficult problem to be solved. As the government of the health emergencies or crisis and the emergency states, I think that this is a matter, again, very problematic, very difficult. There are states in constitutional comparative law, as Portugal, for instance, that in their, or Germany, that have in their constitution a typology of states of emergency. We have not, for instance, in Italy. But I think that notwithstanding the typology already codified in the constitutions or not, it is time for contemporary constitutional legal orders, and therefore for the legislators, to think about a certain evolution and modernization of the typologies codified in the recognized in the constitutions. Because today emergencies are no more war emergencies, or not only war emergencies. They are better climate, energy, health emergencies. It is a very important task for the legislator at every level, particularly the constitutional one, and I will say also the European Union one, trying to connect the two levels. Who is doing what? And this can happen only in a very strict connection between the two levels. Probably this coordination should be adopted also with United Nations. Maybe, as our Portuguese colleague remarked, strengthening the power of WHO. But I see strong problems at the international levels, international in the sense of United Nations level. And the problem is compliance, because many states comply with the directives, legal dispositions, and so on, or emergency powers, other not. For concluding, an inspection to the institutes that probably were the origin of the pandemic was possible only at the mid of 2020. And this is, I think, not a final but problematic reason for doubting about the capability of the WHO to be the engine to solve the problem. Thank you.
Merci beaucoup. Je crois que l'urgence maintenant, c'est la pause déjeuner. Je ne sais pas si notre organisateur, s'il a quelque chose à dire à ce propos. Simplement, dans ce cas-là, la séance est levée, pardon, et la prochaine session aura lieu à 15 heures.